case now before the court is State versus Mace, and both sides will have 15 minutes to present their arguments, and the appellant will have up to 5 minutes to rebut.
Yes, Your Honor. I did not expect to take the full time, but I will reserve the balance of my time for rebuttal. My name is Attorney Joseph F. Salzgeber on behalf of Appellant James D. Mace. This is a rather straightforward case, a bench trial before the Wayne County Municipal Court, in which my client was charged with threatening telecommunications harassment under 291721B of the Ohio Revised Code. That statute creates what is a specific intent crime. The state must prove that it is the specific intent of my client to harass the alleged victim. The burden is not met by establishing only that the defendant knew or should have known that his conduct would probably cause harassment or annoyance. The Ohio legislature created this burden to limit the statute's scope to criminal conduct and not to expressions of mere offensive or annoying speech. The gravamen of the offense of telephone harassment is not the fact that the recipient is annoyed by the call, but rather the state must prove that it was Mr. Mace's purpose to abuse, threaten, annoy, or harass the person called, in this case Mrs. Steele, who is the guardian of Bonnie Hyten.
Frankly, the facts are still confusing to me. What was the ultimate reason for the ill will?
Mr. Mace had been advised by his 24-year-old daughter that she had been receiving harassing phone calls. He was very concerned because she had received. That was not made very specific in the facts of the case.
So subjectively, he viewed them as harassing.
Well, he was advised that some lady was calling her at all hours and harassing her. He was concerned about her well-being because she had been assaulted by the father of her child and had recently had her automobile stolen. So that's sort of the background to all of this. He's being advised by his 24-year-old daughter, I'm getting these harassing phone calls, Dad. And she gives him the cell phone number or a contact number for the person who's been calling her, Mr.
And that person is the guardian.
Yes, the alleged victim, Mrs. Steele, who is the guardian of a longtime friend of the Mace family, Bonnie Hyten, the lady who suffers from mental health issues and was placed in a local Wayne group home.
So how did the daughter get involved in this?
Because the Mace family had been longtime friends of Elmer Mullins and Bonnie Hyten, the guardian apparently felt that contact with people that she used to live with was causing her to be upset, this being her being Bonnie Hyten, and had called to try and keep them away from Bonnie Hyten while she was in the group home. So that's the background to all of this. It's not clear that my client was maybe made aware of this. He only knows that his daughter's being harassed by some woman who's calling at all hours of the day and night.
Comes to a conclusion without any real specifics, correct?
Well, he's told that a woman is calling and harassing his daughter at all hours of the day.
And I presume he heard that from his daughter.
Yes.
And he had an opportunity to ask him what's going on.
Presumably.
Yeah, so we don't know what's going on. We only know that there were communications by phone rather than telling the daughter.
Stay away from Bonnie Hyten, correct. Okay, so with that background, my client calls Mrs. Steele, basically saying, stop harassing my daughter. And he makes this phone call. It's a 2-minute cell phone call to Mrs. Steele. He indicates, apparently he was upset. That was undisputed. It was undisputed that he made the phone call. And he claimed under oath repeatedly he did not threaten to harm Mrs. Steele or her family or damage her property or threaten her job. All he knew and learned during that conversation was that she was the guardian of Bonnie Hyten.
Would it be enough if he threatened her?
The facts of this case indicate that he doesn't He's not aware that that's her
I'm
job.
asking that, sorry, I didn't mean to interrupt you, but I'm just saying, in general, I'm not saying this specific case, but would it be enough if you threaten somebody's job as to telephone harassment or telecommunications harassment?
Well, I think the statute is broad enough to include that. If it's purpose to abuse, threaten, or harass, to threaten someone's livelihood would certainly constitute harassment, I would imagine. But in this case, he doesn't know that she's a court-appointed guardian. This is his first contact with her. And then the subject changes when she informs him that I'm the guardian of Bonnie Heitman and I just want everybody to stay away from her. He then expresses his opinion that, our family's known Bonnie for years. I'm going to go to court and try and get this guardianship changed. And then the conversation ends after 2 minutes. Obviously, Mrs. Thiel was upset about that, but the gravamen of the offense is not that she's annoyed or upset. It's rather his purpose in making the call. And the purpose of making the call was to get someone to stop harassing his daughter, which is what he understood was going on prior to making the phone call.
She testified, did she not, that he said words to the effect that you better watch your back because you never know when someone may be coming up behind you.
Yes, that was part of her testimony. She also testified that he...
Would that be considered a threat?
It could be considered a veiled threat if that was in fact said. However, he denied making any threats at all. He was calling, once again, to get this lady who he thought was harassing his daughter to stop harassing his daughter. Then the conversation changed when she informed him who she was as the guardian of Bonnie Heitman, to his opinion about longtime friends and the significant other, Elder Mullins, being told to stay away from her after 20 plus years of relationship. Based upon the facts of this case, it's our argument that the conviction there was insufficient evidence to support the conviction, and that even if you viewed it in the light most favorable to the state, the conviction was nonetheless against the manifest weight of the evidence in this case. And we would ask the court to reverse this conviction on that basis. Thank you.
Good morning, Your Honors. May it please the Court, Mr. Salzgaber, my name is Olivia Boyer. I am here on behalf of the State of Ohio, the appellee in this matter. Before I dive into the two issues directly before this Court this morning, I think it would be helpful in addressing some of Judge Whitmore's questions with regard to the facts, specifically pertaining to the complainant in this case, Beverly Thiel. Ms. Thiel testified during the trial to the court that she had been doing guardianship work for approximately over 2 decades, and that during the course of her guardianship work in the state of Ohio, never once had she ever had to call the police with regard to threats that were made to her in her work. Now, she had testified that previously, during her work as a guardian, she had been threatened, but she understood where those threats were coming from. They were coming from parents who were upset that their children were being taken away, and she knew the source of those threats. What was most concerning to her in this particular case is that she had never met the defendant before. She had never had contact before. She didn't know what extent he had to participate with her guardianship of Ms. Heilman. Now, the way the defendant, the appellant, became involved in this case is that he was familiar with the ward, Ms. Thiel's ward's boyfriend, a man by the name of Elmer, who was in a 20-year relationship with the ward. They were both having mental health issues, paranoid schizophrenics, and Ms. Thiel, as the guardian, thought it best to end this relationship that was causing issues and separated her ward from the friend of James Mace. And this upset the Maces. Ashley Mace, who's 24 years old, was a close friend of Elmer, identified him as a family friend when she testified before the court, and stated that she was upset and that Mr. Mace, the appellant, was upset by Ms. Thiel taking her ward away from Elmer. And that's what started this. Ms. Thiel was attempting to call Ashley Mace and tell her, do not have contact with my ward. It's causing issues. There's going to be no contact. She's in a group home. Please don't do this. That was the extent.
She started with contact proceedings?
I am not aware. She testified that she had issued a no contact letter to
Is
Ms.
that
Mace.
within her authority to do that?
I believe as the guardian of Ms. Hillman, I believe her purpose in being a guardian is to look out for the best interests of her ward, so I believe so, yes. Because Ms. Mace was attempting to facilitate a relationship that was causing issues for the ward. So Ms. Thiel reached out and testified that she attempted to contact Ashley Mace twice, and that was the extent of the contact. That was it. But that was
You say attempted. Did she get through to Ashley Mace?
I believe so, yes. One time there was a conversation between Ms. Thiel and Ms. Mace where Ms. Thiel testified that Ms. Mace made derogatory statements towards her, excuse my vulgar language, but this is a quote, calling her a bitch. And Ms. Thiel attempted to make it clear that there was to be no contact between Ms. Mace and the ward. Now, Ms. Mace, as testified to by the appellant James Mace, did have an extensive history. There were allegations that she'd been abused in the past, harassed in the past, and that was the basis for Ms. Mace becoming upset. But Ms. Thiel testified that on the date in question, there were actually 2 phone calls. The first being unintentional, where she heard 2 people arguing back and forth, and the quote that Ms. Thiel testified to on page 15 of the transcript was, and this was during the first, she believed, unintentional phone call because there was no one directly speaking to her, quote, "I'm not going to put up with her shit anymore." That can be found in Ms. Thiel's testimony on page 15 of the transcript. And then a couple minutes later, there was a second call. And the defendant acknowledged that there were 2 calls. The first being unintentional, and the second, he intentionally reached out and called Ms. Thiel, making direct contact with Ms. Thiel. Ashley Mace provided Mr. Mace, the appellant, the phone number. He knew it belonged to Ms. Thiel. He knew by calling that number that he would make contact with Ms. Thiel, whether to leave her a message or speak to her directly. And Ms. Thiel, which the trial court found to be the credible witness, found to be the credible party, Ms. Thiel testified that the appellant told her that he would see to it that she lost her job, her house, her car, quote, every damn thing she owned. The victim was so impacted by these statements that she upped her video security surveillance of her home from part-time or temporary to 24 hours a day, 7 days a week, that she put locks on her gas tank, that she distributed photos of Mr. Mace to her neighbors, having never met him before, having no idea as to what he looked like, distributed these photos to the neighbors, and requested that her neighbors, if they saw Mr. Mace on her property, to immediately call the police based on these threats. I think the evidence established that there was a purpose to harass, that there was a purpose to abuse and threaten. Appellant cites to 2 cases where there were convictions of telecommunication harassment, which were later overturned by the appellate court, first being Boniface. But Boniface is extremely distinguishable from the case we have before the court. In Boniface, there were 4 calls over a period of 6.5 months that were the basis for the complaint being filed against the defendant. And there the court found that mere annoyance was insufficient to support a finding of guilty. And I think it's very telling what the complainant had to say in Boniface with regard to phone calls. The complainant was asked to describe the content of the phone calls. And in Boniface, the complainant stated, quote, "I cannot describe the content because I would hang up on her. I didn't want to hear what she had to say." That's very different than what we have here. We have a direct conversation between the appellant as well as the victim, where he made direct threats to her person, saying you better watch out for your back, direct threats to her property pertaining to her home, and even her job. Why? Because he was upset that she was acting as a guardian for a woman that he was familiar with and had known. That's
So
what
if you call somebody and you say, I really don't like how, let's say it's a teacher or something, and you have a problem with them, and say, I really don't like how you handle this situation. I'm going to go to board if your job's done. I'm going to get your job. I'm going to board. Is that telecommunications harassment?
I don't believe so, Your Honor, because that person is acknowledging that they're going to take appropriate measures. They're going to appeal to a higher authority, in that case the Board of Education, and that's proper recourse. That's a civil disagreement. Now, could the tone escalate that? Possibly. But with that type of statement saying that you don't believe someone's appropriate for the job, I'm going to see that you do not have that job, I don't believe that to be a threat.
I thought there was some allegation that what he had said was he was going to go to the court and make sure she was removed to the garden.
Yes, Your Honor, that was the defendant's version of events, which were completely different based on the conversation of Ms. Steele. And the trial court, in rendering its verdict of finding Mr. Mace guilty, found Ms. Steele's version to be far more credible. And as
What was it, I'm sorry, I remember, what was it she exactly said? And I know about watch your back, but about the
Yes.
your house and stuff.
he stated that she would need to watch her back, that he would see to it that the victim lost her job, her home, her car, every damn thing that she owned. That was the entirety of the statement. And Mr. Mace, the appellant, acknowledged and was observed to be upset by the investigating officer, Officer Treppel of the Worcester Police Department. Officer Treppel made contact with Mr. Mace to get his version of the events on a telephone. And she could tell just over the phone in the conversation that she had with Mr. Mace that he was upset. And he was upset. And that's why he called and that's why he made these threats. And given that the court found Ms. Steele's version of events to be more credible and the more likely statement to be made, I believe the state established at trial that there was sufficient evidence, and also that the finding of guilty by the trial court was not against the manifest weight of the evidence.
I'm going to zero in again on putting aside about watch your back. I want to zero in again on his statements to her, to the victim, indicated that he was going to see to it that she lost her job. Couldn't the implication be from that if he saw to it that she lost her job, that she would lose everything she had, she doesn't have employment? Could that be the connotation?
If the only statement made was, you're going to lose your job,
Or I'm going to see to it.
I'm going to see to it that you lose your job, I don't believe that to be a threat sufficient to establish telecommunications harassment. But that's not what we have here. What we have here is the threat to the job, as well as personal items, making it personal to the victim. You're going to lose your home. You're going to lose your car. It was above and beyond.
And that's what I was getting at. Couldn't the implication be with that if you lose your job, you lose all these things?
Yes, that could be a direct implication for making that type of statement. Yes, Your Honor. Now, when looking at the manifest weight of the evidence, a conviction is not against the manifest weight because the trier of fact chose to credit the state's version of events, and that would be State versus Peasley, a decision from this court in 2010, and that's what we have here. The court, in rendering its verdict, stated that it had two options to consider. The first being that of Ms. Steele, the complainant, in where she felt threatened, that the statements were threatening, that they were meant with the purpose to harass her because she was doing her job as a guardian. The alternative was Mr. Mace's version of events, that he called merely to express his disagreement, that he was going to go to the court and request that she be removed as guardian ad litem. And the court chose, the trial court in this case, chose to find the former, the more credible version of events. The trial court went so far as to say that to believe Mr. Mace's version of events would be to acknowledge an individual who's been doing this work for 23 years out of the blue and make a false police report. And the court just didn't find that credible based on her history. And Ms. Steele addressed that, as I discussed earlier. Based on that, Your Honor, I believe the state established at trial that there was sufficient evidence to prove every element beyond a reasonable doubt, and that the trial court's finding of guilty was not against the manifest weight of the evidence. And if there are no further questions from this panel, I will address.
That's fine, thank you.
Thank you.
You have 5 minutes.
Thank you, Your Honor. Just briefly in rebuttal to address Judge Carr's questions. To go to the court and seek legitimate recourse by having a guardian removed, I would argue is not a threat or harassment or annoyance or purposeful threat or harass or annoyance. You're saying I'm going to go through the normal course of procedure and how something should be properly done. I would emphasize that there were no recordings made by Ms. Steele or by Officer Trapalo of the police. My client repeatedly denied under oath that he made any threats. Making a phone call is obviously not a crime. Being upset is not a crime. And my client had a legitimate reason to be upset. He thought that that Ms. Steele had been calling and harassing his daughter, and he was obviously unhappy that contact with a longtime friend, Bonnie Heitman, was apparently being terminated. Based on the facts of this case, we would ask that the court reverse and thank you for your time.
Did your client testify or indicate how many times Steele had called his daughter? Do you recall?
The evidence was that Ms. Steele telephoned to Ashley Mace at least twice on or about October 25th, 2012, which was the day before the phone call from my client to Ms. Steele.
And the letter.
Yes.
So you agree with the state as to the state of the evidence in regard to that?
Yes, we will, I say at least twice in the brief, once from her landline and once from her cell phone, to get a good address for Ashley to mail that no contact letter. So apparently she had to mail the no contact letter as of October 25th.
Thank you.
Thank you.
The court will take the matter under advisement and will issue a written opinion that represents both sides, and you can check